Alrighty then, folks, this is Harrington here. Now, if I appear to be well to say medium well done on your screen, well, it's not your device. I was at the Miami Open earlier this week and I baked up nicely. But you know how I love my tennis? I have no regrets. Now, in reviewing our last few episodes, it occurs to me that I may have just ever so slightly neglected you, my beloved real estate investor clients. So let's get that fixed right now. Today, I want to talk about a hardcore real estate topic, which is deeds. Now, before you make a face and say, Jeff, geez, you got your warranty deed, you got your quitclaim deed, what else there to talk about? I'm out. Well, hold on. I know you people are sophisticated. I'm not going to waste your time. I do have to touch on the warranty and quitclaim deeds because they are a natural springboard, but I will quickly move on to more interesting things like defects in title and a couple of specialty deeds that you may not have heard of before. So let's get it on. This is part one, and it's entitled Quitclaim Deeds, but I'm going to start off by talking about warranty deeds. The warranty deed is just the normal deed that you get after going through a regular closing. Okay, now, if you haven't thought about it before, the warranty aspect of a warranty deed is like a guarantee. When you sign a warranty deed, you are guaranteeing the buyer that the buyer's getting clean title. And of course, if you're going to make a guarantee like that, then you're probably going to have title insurance in place just in case. I mean, if it turns out that there is some kind of a problem with title, I mean, it's likely to cost thousands, if not, millions of dollars to fix that problem. Why would that be? Well, for example, there could be a mortgage that didn't get paid off at closing. Somebody's got to pay that. And don't for a minute think that doesn't happen. I'm dealing with a couple of those right now. But I only take time to explain to you the warranty deed, which I'm sure you're very familiar with, because the very opposite is the quitclaim deed. With a quitclaim deed, you are not making any guarantees of any kind at all. It's a total buyer beware situation. When you sign that quitclaim deed, you're saying to the buyer, look, I'm the owner right now, and I'm going to give you the title to this property. Okay, it may have unpaid mortgages, it may have unpaid utility bills, code violations, liens. I'm not making you any promises of any kind at all. I'm just saying that, whatever might be affecting the title, you're getting it as is. Now, because a quitclaim deed offers zero protections of any kind, it's usually reserved for, say, insider deals. For example, let's say that you have a property in your personal name and you want to retitle it under a company you own or a land trust for, say, asset protection or estate planning purposes. Okay, in that situation, you're not going to go through a full-on closing. You're not going to pay all the intangible taxes and do all the things that go along with a regular closing, title insurance. You're not going to do all that because you're basically selling to yourself. You know what you're getting yourself into. So you just need something quick and dirty. Oh, and cheap. Did I mention cheap? So that's what we want the quitclaim deed for. When there's probably not a bona fide purchaser, there may not be any purchase money going into the transaction. It's just for utility purposes, just to move things around. And that brings us to part two, where I want to talk about defects in title. So now that you understand a quitclaim deed, which tend to be the ones where the shenanigans arise, understand this. The county clerk, will accept and will record any deed that you give her that is properly filled out. As long as it meets the basic statutory requirements, it's going up into the public record. Don't get me wrong. The clerk will be extremely picky about certain specific things, like, they're going to look closely at that legal description. Better have the right number of witnesses per signatory. They're going to look closely at the notary block. Some things they're going to be nitpicky about, but other things they will not. Otherwise, it's going straight up, even if it creates total havoc with the chain of title. Let's take an example, something simple, something like this. The deed one, let's say the grantee of deed one needs to be the grantor on the next deed, right? And then the grantee of that deed needs to be the grantor of the following deed. There needs to be a nice little daisy chain showing the transfers. And that daisy chain needs to be perfect throughout the entire history of that property. Now, as you can imagine, it's not that easy for a problem to arise. Let's say something as simple as somebody gets married. Between the time that they were the grantee on deed one, they got married, their name changed. So by the time they did the deed number two, they have a different name. There are also typos, or maybe on the first deed you included your last name or your initial for your last name, and on the next one you didn't. It could just be small things like that. Oh, here's another one. Or what about you, my Latino clients, my beloved Latino clients? You have multiple last names, or maybe you have a last name that's like a whole sentence. Maria de la Valle, de Todos los Santos. You know what I mean? I kid my Latino clients. But there's some truth to that. So if you have a last name that's a paragraph, every word of that last name has to be the same, exactly the same on each deed, or else we have a defect in the chain of title. Maybe politically speaking, this is not the best time to be making fun of Latino clients, but you guys know I love you, and you also know I can't help myself. Now, let's say there is some small defect, like a typo or some non-substantive issue. You may be able to clear that with what's called a corrective deed, and you better pray that you can. Because if you cannot, then you're looking at filing what's called a quiet title action. That's a full-on lawsuit. You're going to have to serve anyone who might have any remote possible interest in the property. You may have to publish because you're not able to track down some of these people. I mean, we're talking like, goes back years probably. So it's going to be a pain. It hopefully will be a lawsuit that you're fairly in and out of, hopefully it won't get complicated, but you are going to have to go explain your story to the judge. And no matter what, it's an expense and it's a delay that you don't want to have. More than likely, you're trying to sell the property and you can't do so until you've gone through this process. I've got this client. He is a lovely man. You guys would love him if you knew him. And he's a very smart guy too. But for reasons I can't really explain, he filed like 5 or 6 quitclaim deeds. He involved like everybody in his family. Of course, if my firm misses a comma, the clerk kicks it back. But for this guy, she recorded all of them. And as you would imagine, the title is now a complete mess. So, quitclaim deeds. They are quick and easy. But just be aware that the clerk will take whatever you give her, for better or worse. So if you're going to do your own quitclaim deed without involving a real estate attorney and then just take it over to the clerk, you better do it carefully. Point 3, last one. Okay, let's talk about ladybird deeds. So there are some nifty things you can do with deeds, but let me just take half a second to say you should not try to use deeds as a replacement for your estate planning. If you're watching this video, you're certainly going to need a will at a bare minimum. In fact, you're probably going to need a will plus some kind of an estate planning trust, what I would normally call a family trust. I don't want you thinking that you can accomplish the same thing with a ladybird deed that you would with the full-on estate planning documents. But let's say, for example, that most of your assets are in a different state or in a different country. You have your estate planning documents in that jurisdiction, and you just have one property here in Florida. Now, you don't need to redo a brand new set of estate documents for that one property here in this state. So maybe, for example, in a situation like that, a ladybird deed makes perfect sense. But what is that? Okay, ladybird is a nickname. It's technically called an enhanced life estate deed. Say you're living alone and you're getting up a little bit in age. I mean, look, you're good up here, but you can imagine the day where you're not going to want to, or maybe not even be able to, think about succession planning. So you're going to want to deal with this now. All right, you know the person that you want the property to go to when you pass away. But 1, you don't want this person to have to deal with a probate. And 2, it could be that this person would not be the party that would get the property if you did go through a probate, meaning they're not necessarily your next of kin under the statutes. So what you're going to do is you're going to sign this ladybird deed reserving to yourself the right to live in that property during your lifetime. And then when you die, the title will transfer automatically to this person that you've chosen. It's very slick because there's no need for a probate. It just happens as a matter of law. The moment you die, your successor becomes the owner of the property. Clean and easy. And one beautiful feature of a ladybird deed, the enhanced aspect of the deed, is that you retain the right to do whatever you want with the property during your lifetime. So, if you need to rent it, even if you want to sell it, you can do that. Let's say maybe you need the funds for a retirement home or for whatever. You have the right to do that. But I promise that I'm going to keep these videos short for you guys, bite-sized. So I'm going to come back as a follow-up discussion to talk more about life estate deeds, to talk about right of survivorship, because these are important concepts and things that you can do with deeds that you need to know about. Pero recuerda que hablamos español. I will see you guys next week after I go to a second round of the Miami Open. Maybe I'll just be a piece of charcoal by the next time you see me, but I will talk to you more then.